Kyle and Nick, it's great to see you guys. Thanks for sitting down with me to talk about our most recent transactions that we've worked on and some war stories and issues that have come up. So, Kyle, why don't you go first? Tell me something that's happened on one of the transactions you've worked on recently.
Yeah, so we were actually representing a tax equity investor in a portfolio of solar projects throughout the country. And as part of that, our typical due diligence work, we of course ran title and reviewed the survey. And as part of that, we always request that the survey include an overlay of the solar improvements, the solar panels and other facilities for the project. And in reviewing for one of the projects, that Alta survey with the overlay, we realized that there were actually solar panels that were located not only on the leased property where the developer had rights to install those and build those, but also across a property border on an adjacent property owner for which they had no rights to construct the project.
Somebody that wasn't part of the project at all.
Correct. Yeah, it was just an unrelated third party that just happened to own land right next to the project.
All right, I can't wait to hear how that was resolved. What about you, Nick? Do you have any war stories you can tell us about?
Yeah, so we were recently representing a client who was acquiring 3 energy projects, and 2 in Texas and 1 in California. And when the title search came back, reviewing the title commitment, we located a deed to the project company that was not located anywhere in the diligence materials, but was actually just an exception document in the title commitment. And so when we discovered this, we asked the seller if they knew why they owned the land, if they still own the land. They had no idea that they owned the land. We confirmed that they did in fact own the land, and that if our client acquired the project company, they would be acquiring that land too without knowing it.
Because it was a MIPA transaction?
Because it was a MIPA transaction, and so the client was acquiring the project company.
Acquiring everything that the company owned, right?
That's exactly right.
Wow. We'll have to dive back into that and see how that was resolved.
Well, how about you, Carl? Any recent matter or transaction you worked on that an issue popped up?
Well, just recently we worked on a matter where a client was acquiring a piece of property that was next to a potential data center development, and they were going to put battery storage on the property there for that data center development. And the data center developer actually terminated an access easement like right before the closing. So we were scrambling to try to figure out what to do with respect to that. And I'll have to tell you more about that as we get on. But let's go back to you and your issue with respect to the solar panels built on somebody else's property. So
Yeah.
So what did you do to fix that?
Well, I guess I want to also go back to kind of how we discovered the issue as well. So this was part of a tax equity transaction, and so there'd actually already been debt financing.
Oh, really?
The lender and their counsel, had already done title, survey, and other due diligence. And because that lender and their counsel did not request an overlay of the proposed improvements on the survey, they didn't see that issue.
Mm-hmm.
And so that's definitely something that, when we're representing both in debt financing and tax equity, is to make sure you get that overlay, because it shows, where the improvements are going to be located and potential title and survey issues with existing easements and other matters of record. But anyway, in this situation, what we did was we were actually able to work with the developer, who was the borrower here, the landowner who owned the land where the lease premises for the project was located, the adjacent landowner where these panels had been built, and the local jurisdiction, to coordinate having a boundary line adjustment recorded that actually moved the boundary line so that all the improvements were located on the leased premises where the project was located.
I would imagine that adjacent property owner had a bit of leverage there.
He did.
Yeah.
Luckily, it was a much easier process with them, as you may think, and the actual local jurisdiction was on board, I think, because they were on board for the project. And so at the end of the day, we were able to get to an acceptable solution for everyone involved.
Well, and a boundary line adjustment is a lot easier than having to do a subdivision.
Correct. Yeah, correct.
The reason why you have the overlay of the site plan on the survey, 1 is to see this kind of stuff, but 2 is to get your title endorsements, right?
Correct. Yeah. So in order to get the energy endorsements that we typically look for, the surveyor needs to actually plot where the proposed improvements are, and then once the project is actually built, do the as-built location for the improvements. Yes.
And the endorsement is one that says that the title company says, we will ensure your ability to build the project on the land.
As it's shown on the survey with the overlay, yes.
Right, exactly. So, and without that, this wouldn't have been found. No telling what would have happened.
Who knows what would have happened, yes. But at that point, our client, the tax equity investor, would have had money and skin in the game. So it was good to find this issue before the underlying agreements had been entered into.
Right. Yeah. Well, good job working that out. Yeah. So what about you, Nick? How did you resolve your issue?
So we had to research the land and review the title. Obviously, we had to update the title commitment to include that land, confirm that the project company actually did own the land, and make sure that that land didn't cause any future liabilities to the project company that our client would undertake when it acquires it in the MIPA transaction. And so we actually determined that the land should have been conveyed to a third party back when the project was constructed, and the deed was just never given to the third party. And so for all intents and purposes, the project company still owned this land that they weren't supposed to own. And so prior to closing on the transaction, we ensured that as a CP to closing, the recording of that deed and the giving of that deed to the third party was done.
So your client actually, when they acquired the membership interest, you made sure that that property was conveyed out. So you didn't have to run due diligence on that property and make sure there was an environmental contamination or any other issue associated with owning that property.
That's exactly right. Yeah, we did review just to make sure there wasn't any tail obligations that could potentially arise from owning the land at any point in time. I think the client, out of an overabundance of caution, did run a phase one just in case to make sure they weren't picking up any circular liability. But we did make sure that that land was conveyed out and didn't present any future liability to the project company.
And we're not environmental counsel, we're real estate counsel, but we do some environmental work. And so with respect to circular liability, explain that a little bit. Are you saying that anybody that has owned property can always have liability with respect to environmental contamination?
Not necessarily always, but the safe harbor is to perform a phase one assessment on property before you take ownership of it, to ensure that you avail yourself of the protections under CERCLA. And while we're not environmental counsel, real estate and environmental are often intertwined in their scope. And so we work very closely with environmental counsel on a lot of our transactions to make sure that our clients are protected from any future environmental liability.
Fair enough.
Well, how about you, Carl? I'm interested to learn how you figured out this access issue.
Well, our client actually received a notice letter from the data center developer saying that they had terminated the access easement, and sent a copy of the document that they recorded to purport to vacate the access easement. So we then had to research and look into whether or not that vacation of the access easement was valid, first of all, because they said that they were terminating because of the doctrine of merger, because they owned, say, for instance, parcel A and parcel B, but we were parcel C. And so they really couldn't terminate it as to parcel C. But then as we dove into it a little more, the grant of the easement to parcel C was really granted from parcel B, and we needed it to flow over parcel A as well. And so we explained to the client that the original grant of the easement may not have been valid, and there arguably was a grant of the easement way back in time, and the closing was imminent, and really actually the client decided to close without that access easement, but was able to obtain a option to obtain access to a different public right-of-way to protect its access to the property, and then fight the battle with the data center developer at another time. And they decided to not get an access endorsement in their title policy when they closed, and we may get an updated title policy that includes the access endorsement. They have a good relationship with the data center developer, and they're hoping to enter into an agreement with the data center developer for the storage of energy for the project, for the data center project.
Yeah.
And so they decided to go ahead and move forward with that known risk.
Gotcha.
It seems like, these projects, a lot of the diligence can raise issues, but if we're able to identify them, we can use pragmatism to work around them as long as we know about them.
That's right. And my project was really a real estate driven project because the battery storage company was acquiring that property. But it sounds like your projects were more part of a larger project, part of tax equity financing, and then yours was an M&A transaction. Is that right?
That's right.
Yeah, for sure. Yeah. And so this was just one of many issues in the overall transaction because it was a portfolio of numerous solar projects. And I think there's a necessity for working closely with other experts in the other sectors like environmental or corporate or various sectors to make sure that as a whole, your client is comfortable with what they're acquiring, not only from a real estate perspective, but from every other perspective, for sure. Yeah.
Yeah, and I found that the people at Troutman, the other attorneys that we work with that are in the corporate side, they do a really good job of bringing us on and keeping us involved from the very beginning with respect to, one, negotiating the reps and warranties, the conditions to closing and those types of transactions, and getting us involved early so that, one, they have our expertise, two, we can point out any kind of these red flag type issues to the client before it gets too far down the road.
Yeah.
Which is really important because, I think you've said this to me before, Nick, that really without the dirt, you really don't have a energy project. And it's really important.
And a lot of times when, at least in my experience, when you're dealing with investors, they may not have a real estate expert in-house. Instead of looking at us to give that guidance and that expertise. And so I think they do rely on us. And I think it makes that much more important to make sure we're doing the title and survey and other due diligence that's necessary to make sure that they're buying a viable project.
Right. Well, this has been great. I've really enjoyed talking to you guys about your war stories and things that have happened in your practice. The one thing that really is beneficial is hearing your war stories kind of educates me about things to do and lessons learned. And so I really appreciate it.
Yeah, thanks.